I wanted to talk separately about capital punishment, just because it is a very controversial issue, and it is something that the law changes on a lot. States are flip-flopping on whether or not they will require capital punishment. They change their method of the implementation of the death penalty. The federal government has made statements about the death penalty, and in Texas, we are a death penalty state. And so since this is something that is at the forefront of our criminal justice system, it's something that we should at least have a background and understanding, and also spend a little bit of time thinking about your feelings about capital punishment and whether or not it is justified or not. So we've talked about the goals of punishment in other lectures, but some of the goals of punishment are justice or social vengeance, which means settling accounts with those who have violated the law. Basically, making sure that somebody who has violated the law has paid for that, so that, to the same extent of the harm they caused. Isolation, meaning protecting society from a future crime from this person. Rehabilitation, which is correcting the criminal's attitudes and behaviors. Or deterrence, either specifically discouraging this person from committing another crime, or generally discouraging society from committing crimes because they'll see the example of this person and say, that's something that I don't want to happen to me. So, as I said, Texas is a death penalty state. Texas is one of the highest rates of imprisonment. We're number 7 in the nation for people in prison, number 10 in nation for the people on probation, and number 5 for people on parole. So we're at the very top of the list. Texas has a higher crime rate than 32 other states. So while our crime rate is going down, it is still higher than many other states. Texas's murder rate exceeds the murder rate in most other states, and we execute more people than any other state. Now, you may say that that's because we have more people, but we don't have the most people of all states, yet we do execute more people than any other state. 80% of felonies are committed by recidivists, which is repeat offenders, so people who have already got a criminal record commit another felony. And half of those released from prison will be arrested again within 3 years of release. Now, there are 100 things we could talk about here as to why those people will be arrested again within 3 years of release. Are they being watched more carefully? Are they in a group that is arrested more frequently than others? Do they lack a privilege that other people who are not arrested at the same rate have? Those are all debatable issues, but the statistics show that half of the people released from prison will be arrested again within 3 years. So let's talk about how the procedure works with the death penalty. You commit a crime that's a capital offense. So this isn't any crime, it's a specific crime. You're arrested for that offense. You're arraigned, being told that what offenses, what charges are being brought against you. You go through a trial, which has a jury of your peers. You are allowed the assistance of counsel, appointed if you can't afford a counsel. You have the right to fair evidence being produced against you. You do not have to testify against yourself. The Fifth Amendment right against self-incrimination applies not only to the federal cases, but to state cases as well. A jury will render a verdict, and it has to be unanimous. And then the trial judge has to not overturn that verdict. So even after a jury issues a unanimous verdict that you should be put to death, the trial judge can overturn the verdict as not supported. Then you have a right to an appeal. And we've talked about in previous lectures that your appeal goes from the district court straight to the Court of Criminal Appeals. You bypass all of the intermediary courts. And then you also have chance for clemency. So the governor can be more strict, but not less strict than the Board of Pardons and Paroles. But the governor has certain options to stay in execution, and the Board of Pardons and Paroles can grant clemency. So let's talk about the first point there, committing a crime that's a capital offense. So capital offenses are very specific, and I don't necessarily want to read you this entire slide because I know that you can read on your own. But you have to realize that the individual that is killed is a peace officer or fireman in the line of duty, and the person knows that the individual is a peace officer or fireman. So that is not just you shoot your neighbor who's a cop while he's in his backyard mowing his lawn, that you know that you necessarily are going to be subject to the death penalty. There are certain felonies that are death penalty felonies, capital offenses, that if you kill someone during the commission or the attempt of these other felonies, that you could be subject to the death penalty. Murder for hire is a death penalty offense, both for the person who hires and the person who is doing the killing. And then if you're, you know, there are a lot of protections for prison guards that that are death penalty offenses. So if you kill somebody who is an employee of a penal institution, the prison system, or killing occurs during an escape from the prison system. If you commit a murder during or in connection with organized crime while you're in prison, things like that. So that is to protect the people who work in the prison system from, being killed or being, hurt from people who are already in prison. And then you can also, if there's a killing of more than one person in kind of a same scheme of crime, so if a serial murderer is a capital offense, you kill someone who is under 10 years old or somebody who's a judge, or in retaliation for something the judge did, then those are all capital offenses. So, arrested, arraigned, meaning you were brought before a judge and said you were charged with this capital offense. How do you plead? Do you want a lawyer? That's what your arraignment is, and it has to be speedy. And then you are entitled to a trial. So during your trial, the jury is asked, after the jury hears all of the evidence and finds you guilty of a crime, the jury's asked whether there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. So that's the standard, continuing threat to society. And if the jury charge permitted the defendant to be found guilty as a party to capital murder, whether he or she actually took the life of the deceased, intended to kill the deceased, or anticipated that a human life would be taken. So this allows you to be charged with a criminal offense, even if you did not pull the trigger, or you pulled the trigger and the person didn't die because of your gunshot. If the jury of 12 people unanimously answer yes to both of these questions, then the judge asks whether, taking into consideration all of the evidence and circumstances, the defendant's character and background, and the personal and moral culpability of the defendant. So the personal guilt of the defendant. There are sufficient mitigating circumstances to warrant that a sentence of life in prison without parole be imposed rather than the death sentence. So is there any reason why we should not give this person the death penalty? And if there are no mitigating circumstances, then the person is sentenced to death. At the time of the sentence, the person goes to death row, and they're housed separately from the rest of the prisoners, and they are in isolated single-person cells that are very small, but they have a window. They don't get to have recreation with everyone else. They don't have a TV. Some people are allowed to have radios. Okay, so we've talked about the appeal before, which just means you go straight to the Court of Criminal Appeals. And now let's talk about clemency. So clemency is given by the Board of Pardons and Paroles. So the board members have the responsibility of determining what the procedures are for parole and mandatory supervision, but they also vote on whether or not there is going to be clemency granted. These board members are appointed by the governor, but they have to be confirmed by the Senate, and they have 6-year terms, and they're not always up for reappointment every year. The governor has the authority to grant clemency if the majority of the boards of pardons and paroles recommends it. And this is a full pardon after conviction or a completion of a term of a deferred adjudication. Deferred adjudication means that if you can go a certain amount of time without committing a crime, then it will be as if you did never commit the crime. So for example, I got deferred adjudication one time when I had a traffic ticket. And so what that means is if I went for 6 months or something like that, a year, without getting another speeding ticket, then it was like I never got a speeding ticket at all. And so that is what deferred adjudication means. So after successful completion of a term of deferred adjudication, community supervision, conditional pardons, meaning pardons for maybe some crimes but not all of them, pardons based on innocence, or commutations of sentence, so meaning you're making a death sentence into a life sentence or something like that, and reprieves. In capital cases, clemency is commuting a sentence from the death sentence to a life in prison or a reprieve of execution, meaning you are not going to be executed. The governor can grant a one-time reprieve of execution without board recommendation for 30 days, but that is 30 days period. So once per death row inmate, period. The board doesn't meet as a body. They each consider a case that is being asked for clemency, and they fax their vote to the governor. I don't know if these procedures have been updated to allow for emails or things like that, but right now it's the way it's written is that they fax their vote to the governor. The governor can request that the board members issue a certain ruling, so can say, I would like you to review this case and, recommend clemency or something like that, but they don't. The board members don't have to agree with the governor's recommendation. A parole board's vote is taken usually the day of execution, and the decisions are rendered by a majority vote. I don't have any reason for why this is done the day of execution and not the day before or 3 days before or a month before or anything like that. A favorable recommendation must receive the governor's approval in order to take effect. So if the board votes for recommending that a person is granted clemency, then the governor has to approve. And if they reject, if the governor rejects the recommendation for clemency, then the person is not given clemency and is still executed. Without a court ruling or board recommendation, there's only one person who can stop the execution, and that's the governor, and he can stop it for 30 days. But this can only be used once per prisoner. So even if the governor, say Governor Perry, issued a 30-day stay of execution, and then that 30 days turns into 60, 90, 180, whatever, and it goes on and on and on while there are appeals in the middle and things like that, and then there's a new governor, and so Greg Abbott is the person comes up for execution again. Is Greg Abbott allowed to issue a 30-day stay because he hasn't issued a 30-day stay as to this person? The answer is no. The governor, even if it's the successor to the person who actually ended up doing it, the governor's office cannot issue another stay for that prisoner. So these are the things that the boards of pardon, members of the boards of pardon and paroles consider and do and vote on. So there's lots of different things, but I've put the big ones in red. They interview inmates, they interview victims, they interview other people like family members, attorneys. They make recommendations to the governor if people should be granted clemency. And then they also make information available to the public and to appropriate state agencies. So they give information regarding prisoners and also prison statistics and certain cases available to the public. I've put some of the members of the Board of Pardons and Paroles on the next few slides, just so you know. They come from different areas of Texas, and you'll kind of see how they had, what kind of background they have, and for example, Mr. Gutierrez was a sheriff for a number of years. Mr. Jernigan had many years in the criminal justice field and has worked, in the federal Treasury Department too. Ms. Jones was a sheriff, or is a sheriff, and Mr. LaFavors was a police officer and had years of investigation, and he was an investigator with a law firm. Mr. Long has, like most of the others, has a criminal justice degree, was a sheriff, a parole officer, and Mr. Robertson had urban administration degree and has more of a I would say an accounting or a business side background than necessarily the board, the criminal law background that the other members have. And then Mr. Solis had, he had Army experience, police officer experience, and criminal investigation experience. So you see that the people that are on the Board of Pardons and Paroles generally have a background in criminal justice and know kind of, they're familiar with pretty sophisticated criminal law and are, thought to be the people that would make wise decisions based on their background. So let's talk a little bit about the nuts and bolts of an execution. Executions are scheduled for 6 o'clock on a weekday, so not first thing in the morning and not midnight, not on the weekends. I think this is for a reason, because they want to, make sure and minimize protests and disruptions, things like that. The final countdown begins when the person's transported to the Huntsville unit. If they're not already at the Huntsville unit, usually the morning of the execution. There are no interviews allowed on execution day. Texas used to have the, what you can choose anything for your last meal, but now people that are being executed are served the same meal that evening as everyone else gets. Witnesses for the person being executed, but also witnesses for the victims arrive in separate waiting areas. They're not all waiting in the same waiting room. The state employee counsels the victim's witnesses regarding what they're about to see, lets them know what the witnessing an execution will be like. Prison officials and media gather in the administration building to wait confirmation that the execution is going to proceed, because often, like we talked about, there's clemency, there are final votes being taken, there are 30-day reprieves being given, and so instead of waiting in a waiting room, they wait in the administration building. There are 5 media members that are allowed to witness execution. 2 of those are for the Associated Press and the Huntsville Item, which is the local newspaper, and the other 3 are allowed by the prison officials at their discretion, but they have a Texas First policy. So Texas media is going to get priority over something like the New York Times. And then when the execution is a go, when there are no grants of clemency or reprieves of execution, the officials and the media walk across the street and split up, with one prison official and some media going into the prisoner's witnesses waiting room, and then another going into the victim's waiting room. But reporters can't interview people who are the witnesses in the viewing room. And so after that, a prison chaplain, is attending to the prisoner during the final hours if they need anything or want to talk about anything. And at 6 p.m., the prisoner is taken from the holding cell outside the execution chamber and taken into the chamber, strapped to the table, face up with his arms extended. And then when the prisoner's in place, a guard escorts 2 witnesses, parties into their rooms. So the prisoner's witnesses and then the victim's witnesses have separate rooms. And so they are, when they enter the room, they see the person already strapped down. IVs are given in both arms, and a saline solution is started. And after saline's flowed for a few minutes, everyone leaves the chamber except for the prisoner, the warden. There used to be the chaplain left in the room, but right now it's just the prisoner and the warden. The warden stands behind the prisoner, and the prisoner is allowed to make a last statement. And there's a microphone right above his head. And so he's allowed to make a last statement that is played into the 2 different waiting rooms. And as soon as that's finished, the warden signals for the lethal dose to be administered, and there's an anonymous executioner in another room that releases a lethal dose by remote control. So nobody knows who that anonymous executioner is, so that there's no, retribution against that person. And the drug that is used for executions, you may have seen in the news that the manufacturer of that drug is refusing to sell it. And so there have been there were some delays on executions and things while there was, an alternate drug, researched and determined whether it would be adequate for this. The prisoner loses consciousness in about 10 seconds, but there are a few minutes before the prisoner is actually pronounced dead. And usually the pronouncement of death comes about 6:20, just after, kind of after everything has happened. So, what do we think about all of this, everything that we've just heard? Some people are very much in favor of the death penalty. They say, that the case for the death penalty is that there are certain crimes that are so heinous that the only punishment that serves the interests of justice is capital punishment. There's an argument that capital punishment deters this person from ever committing a similar offense again. Obviously, they won't be able to because they will be dead. And it also deters others from committing a crime because it means putting their lives in jeopardy. So if I see that people who, shoot police officers in the line of duty are being put to death, then the argument goes, that would deter me from wanting to shoot a police officer in the line of duty. It also arguably protects those working in prisons, since criminals serving a life sentence would not really have a deterrent from killing a prison guard or engaging in organized crime or other activities that results in the death of somebody in prison. And the threat of capital punishment assists law enforcement in solving crimes because it encourages testimony by other criminals or co-conspirators. So a lot of times the promise that somebody will be spared the death penalty is enough of an enticement for them to work with law enforcement and maybe say, yeah, I was there, we were all planning on killing this person, but this was the actual trigger guy. So what's the case against the death penalty? Historically, states with the death penalty have higher murder rates than states without it. I don't know why. In 2016, the South had 80% of all executions and the highest murder rate, and the Northeast, which had 1% of all executions, had the lowest. So I don't understand these statistics or why these things happen. I don't think there's a single answer for that. Some people argue that killing is never just, even when it's for a punishment for a crime. The argument is that if an innocent person is executed, justice can never be served. And so basically, nobody should be executed because if there's any chance that somebody who is innocent of the crime they're accused of is executed by mistake. There have been 12 people on death row in Texas that have later been exonerated of their crime. And so arguably 12 times in Texas, at least, it has happened that an innocent person has been executed. There is an argument that there are alternatives, life without parole, and they are far less expensive. Again, it's more expensive to execute somebody than to imprison them for life. The trend is to avoid the death penalty. 19 states have abolished it, and most of the remaining states that even allow the death penalty won't seek it, just as a matter of policy. There are only 8 states, mostly southern, who executed people in 2018, and most of those people were executed in Texas. The argument is that the death penalty is cruel and unusual punishment and violates the 8th Amendment. There's a lot of Supreme Court activity about whether or not the death penalty is cruel and unusual punishment. Is a hanging in order to achieve the death penalty cruel and unusual? Here are the drugs that make the person seem unconscious, actually sparing them from pain, but nobody knows they're in pain because they're paralyzed. Is that cruel and unusual punishment, if that in fact happens at all? And then finally, like I mentioned before, the drug companies don't sell the drugs, and that shows that when drug companies will withhold the drugs that are used for executions, does that show that just society in general thinks that this is a bad idea, and so the death penalty should be abolished? Those are the reasons for, the reasons against. I can't tell you. I can tell you that it's legal in Texas. I can't tell you if you think it should be legal. That's something that you need to come to your own belief about. I will tell you about 2 different cases, though, in Texas that have ended up in the death penalty and kind of the different, or an issuance of the death penalty, and kind of the different reasons for that. First is the case of Cameron Todd Willingham. In December of 1991, Willingham's house with his 3 daughters was burned down, and his daughters died. Mr. Willingham was in jail, and Mr. Webb was an informant who testified at trial that Mr. Willingham confessed to setting the fire. He was convicted based on the fire being deliberately set. There was evidence that it was actual arson, and there was Mr. Webb's testimony that Mr. Willingham was the one who set the fire. However, in 2004, there were independent fire investigators that said, actually, we don't think the fire was deliberately set. So this was not somebody hired by Mr. Willingham. This was an independent party. Mr. Willingham was executed in 2004. And in 2014, Mr. Webb recanted his testimony, saying that he actually made up the confession by Mr. Willingham because the DA, the district attorney, promised him leniency on his own aggravated robbery charge. And so the district attorney allegedly told Mr. Webb, if you will offer testimony about Mr. Willingham confessing to setting the fire, then we will move your aggravated robbery charge to a simple robbery. So next, we'll talk about the case of Rodney Reed. So this case was in the news a lot last year, and so you may have heard the name Rodney Reed, and you may have seen the picture of Mr. Reed. So in April of 1996, a lady named Stacy Stites got off work and went to her mom's house in Giddings, Texas. And she was 3 weeks from her wedding to a guy named Jimmy Fennell, who was a rookie patrolman with the Giddings Police Department. So Fennell and and went over to Stites' mom's house, ate sandwiches, and then around dusk, Stites and Fennell went upstairs to their own apartment at her mom's house. Fennell did not wake when Stites left at 2:45 in the morning and borrowed his truck to go to work. So she allegedly went to work at 2:45 in the morning. But then on April 23rd, at 6 a.m., a coworker called Stacy's mom and said she wasn't at work. She must have overslept. Could you please go tell her that she's late for work? Even though she allegedly had left at 2:45 in the morning to go to work. Stacy's mom called Fennell, and he raced to the store in Bastrop, 30 miles away. They found his truck that Stacy had borrowed to go to work at 2:45 in the morning at Bastrop High School in the parking lot, and there was a shoe and an earring that was in the truck and a foamy substance. The truck was processed, meaning all of the evidence was lifted and examined by the Department of Public Safety in Austin, and at 3 p.m. that day, Stacy's body was found in a ditch outside town with bruises on her face and shoulder and ligature marks or choking marks that matched her belt, which was nearby on the seat, and that was what had been used to strangle her. And there was also semen found at the site. The next day, the Travis County medical examiner performed an autopsy and said that she was killed at 3 a.m. Remember, she had left her house at 2:45 to go to work. She was killed at 3 a.m. The medical examiners can look at the temperature of the liver and determine pretty accurately when the person stopped living. The Department of Public Safety processed the truck and found nothing helpful, and they returned that truck to Mr. Fennell, who immediately sold the truck. Fennell's DNA did not match the semen that was found on Stacy or around Stacy. He failed 2 polygraph exams when asked if he had strangled Stacy. Investigators couldn't figure out how he killed her by 5 a.m. and then left his truck 30 miles from home and got home at 6 a.m. Basically, it was just too much of a logistical issue. If he was called by his mother-in-law at 6 a.m. and he was at his house 30 miles away, how would he have killed her and then gotten home in time? The apartment that they shared was never searched for any kind of evidence. Now, the evidence of Mr. Reed comes in when there was a Bastrop police officer who saw Mr. Reed walking late, night after night. He was a former boxer who lived in Bastrop, and so the Bastrop police officer asked if they could get a DNA sample, and they had one already from Mr. Reed from a woman who accused him of sexual assault months earlier. And it was a kidnapping, attempted murder, and a rape of a woman named Linda Schulater, and she had accused Mr. Reed of attempted murder and rape, and so they got a sample from him in connection with that case, and it matched the sample that was found near Stacy. Reed said that he didn't know Stacy Stites when he was questioned. So in 1997, Mr. Reed, Rodney Reed, was charged with rape and murder of a white woman. He is a black man. The jury was all white. There were no witnesses, no physical evidence other than the DNA that was in the truck. There was hair that was found on Stacy's body that did not match Mr. Reed. The theory was that as Stacy drove to work on April 23rd, Mr. Reed, who had no vehicle and no weapon, got into her truck, raped her, strangled her, dumped her body, and then abandoned the truck. This sounds like a pretty sloppy crime, but there were not any fingerprints of Mr. Reed's in the truck. The defense said somebody else, probably Mr. Fennell, killed Stacy, and that Mr. Reed was having a secret consensual relationship with Miss Stites. The defense witnesses showed that family and friends of Mr. Reed had knowledge of the affair with Stacy, and there were criminal records that were associated with Mr. Fennell. The jury found Mr. Reed guilty. The all-white jury found Mr. Reed guilty. Prosecution moved for the death penalty and put up 5 witnesses who had also claimed to have been sexually assaulted by Reed. Only one of those had actually gone to trial, and Mr. Reed was actually acquitted of that crime. But the death penalty was sought because he had this history of rape, allegedly, because there were all these other cases out there. So there were appeals based on new witnesses that were located saying that Mr. Reed really did have an affair with Stacy Stites. There were new witnesses saying that Mr. Fennell Officer Fennell had inappropriate conduct with women. There was an appeal based on Mr. Reed's ineffective assistance of counsel, saying that his attorneys didn't effectively assist him by doing enough of an investigation. There was allegedly evidence that was withheld by the prosecution, and so that was a basis for an appeal. And then there was a question about whether the forensic scientists mishandled evidence or were wrong. And those were the basis of appeals. All of those appeals had been heard, and there was no retrial. Mr. Reed sought an appeal to the federal district court, saying that there's new evidence regarding Mr. Fennell, saying that he broke up a domestic dispute in connection with one of his cases, and as his partner took the boyfriend to jail, Fennell took the woman to a park and forcibly raped her. He gave her a business card and said that if she, told anybody, he would kill her. He had been charged with kidnapping and rape, but pled to inappropriate sexual conduct and got 10 years of probation. 10 years in prison. And after his 10-year prison sentence for kidnapping while he was an officer in Georgetown, and there were records of his service that showed that he had a history of violence against women, stalking them, sexually assaulting them, and then there was a person who was a wife of a coworker who thought that he might be guilty of killing Stacy Stites. The appellate judge heard all of that evidence and said that, yes, Mr. Fennell or Officer Fennell is a despicable and reprehensible person, but that doesn't mean that Mr. Reed is not guilty. He didn't buy that Mr. Reed and Miss Stites were having an affair, and so the appeal was denied. So now Mr. Reed finds himself sitting on death row. There was a murder weapon, the belt, that was never tested for DNA evidence to determine if there was any of Mr. Reed's DNA on that belt. There was a retired homicide detective who was doing a piece on the case for a TV show in Texas, and noticed that the lividity, which is these purple splotches that pool on somebody after they die. So if you are killed face up, then the lividity, the pooling of the blood and the purple splotches would be on your backside. So this retired homicide detective noticed that the decomposition and the lividity, the pooling, showed that Stites was murdered hours before the state said she was. That there were 3 forensic experts for the state that admitted that they gave errors in their testimony, and their opinions were the basis of the conviction. And they said that their time of death that they originally said wasn't necessarily accurate. There were 4 forensic experts that concluded that Mr. Reed's guilt was medically and scientifically impossible because Miss Stites was killed many hours before they were notified of her disappearance, not within the 2 hours that the prosecution witnesses had said. Basically, the forensic experts found that the timelines didn't add up. Other experts agreed that Miss Stites had laid face down in the for 4 or 6 hours before being dumped in the ditch. The foamy substance that was found in the car was what's called purge fluid, which is what the body produces after a person's been dead and their body has been sitting for many hours. The time of death was then put at 11 p.m. When Miss Stites was allegedly at home with Mr. Fennell. And there was evidence that Mr. Reed could not have killed her between 3 and 5 a.m. as the prosecution story went. There were 3 new fact witnesses that were not connected to Mr. Reed who knew of their affair, so not his friends and family testifying on his behalf. There was a coworker from HEB, so one of Stacy's coworkers, who testified she was not excited about getting married because she was sleeping with a black guy named Rodney, and she didn't know what her fiance would do if he found out. Another coworker saw her flirting with Mr. Reed, and a cousin of Stacy's said she saw Stacy and Mr. Reed at Dairy Queen one time. It's a very Texas alibi right there, that you were at Dairy Queen. So the Court of Criminal Appeals granted a delay 10 days before the execution in order to look at new evidence. In October 2017, there was a hearing on the expert testimony regarding changing the time of death. Curtis Davis, who was the best friends of Officer Fennell, gave a different account of their whereabouts during of the night of the murder, and then the 3 witnesses, the 3 non-biased witnesses to the affair. The judge denied a new trial. The Court of Criminal Appeals agreed and scheduled an execution for November 20th. The courts found that the evidence, any of this new evidence, doesn't change the fact that Reed's semen was found in Stites' body, and And this is where we get the, other than showing that Fennell has engaged in reprehensible and despicable conduct as an officer with the Georgetown Police Department, the court wrote in an unsigned opinion, the information does not exonerate Reed of Stacy's murder. They say it arouses a healthy suspicion that Fennell had some involvement in Stacy's death. We are not convinced that Reed has shown by a preponderance of the evidence that no reasonable juror confronted with this evidence would have found him guilty beyond a reasonable doubt. So basically, what this is saying is that Reed had to show just any tip the scales, minuscule amount, showing that no reasonable juror, given that evidence, would have found him guilty. And the court said that he didn't meet that burden. So there was more new evidence. There was an anonymous witness who said that he signed up Miss Stites for life insurance in the weeks before the murder, and then when Stacy had wondered why she needed life insurance since she was so young, Officer Fennell said, "If I ever catch you messing around, I'll kill you and no one will ever know it was me that killed you." So that's something that, the person that was signing up for life insurance witnessed. There was somebody, a former Giddings Police Department officer named Jim Clampett, of course, very Texas name, who heard Officer Fennell say, "You got what you deserved," when he was at Miss Stites' funeral. There was somebody named Charles Wayne Fletcher, who was a former police officer, who heard Fennell say at a barbecue that he thought his fiancée, Miss Stites, was sleeping with a black guy. Arthur Snow, who was a former cellmate of Fennell when he was in prison for 10 years, was approached by Fennell asking for protection of the Aryan Brotherhood, and they talked about his ex-fiancée who was sleeping with a black guy and that he had killed her. There was Richard Derleth, who was a deputy at the Bastrop County Sheriff's Office, who said that coworkers of Miss Stites would warn her when Officer Fennell visited so that she could hide from him. Another coworker said that Miss Stites reported being scared of Fennell because she was having an affair with a black guy. And the former downstairs neighbor said he heard Officer Fennell and Miss Stites fighting, and they always thought that Fennell was physically abusive of her. And Fennell gave an inconsistent account of where he was at the time of the murder, according to his friend, Curtis Davis. He had said they were out drinking, but then later he said he was with Stites in their apartment during the time that was the new time of death. So, what you need to know about the people who are deciding whether or not Mr. Reed was going to be spared from the death penalty or not, Greg Abbott, who's the governor, but before he became governor, he was a pro-death penalty attorney and the Attorney General of Texas. 13 Republicans and 13 Democrats from the Texas House and 8 Republicans and 8 Democrats from the Texas Senate have asked for a delay of execution. The Republican Party of Polk County asked for clemency, and Ted Cruz asked for a delay of execution. Ted Cruz is a Republican senator from Texas. So this was, people who were from Greg Abbott's party who were asking for at least a delay in the execution. So where the case stands now is that the U.S. Supreme Court has declined to hear the case, but there was significant public outpouring about the case, significant national attention, And from a website called freerodneyreed.com, today's update is, thanks to massive pressure, the Texas Court of Criminal Appeals ordered an indefinite stay of execution, but he's still in jail and there will still be a trial. Okay, so last thing about the death penalty. So if you are mentally ill or mentally incapable of committing a crime, or are you mentally are you prevented from being executed? So the Supreme Court has said that a defendant's mental illness makes him or her less morally culpable, so less able to be be held wrong, and must be taken into consideration as an important reason to spare his or her life. However, as was initially the case with intellectual debility and young age, the court has not barred the death penalty for those with serious mental illness. So as it stands today, if you're seriously mentally ill, that is something that can be considered and should be considered as a mitigating circumstance as to why you should not be executed. But it is not, the Supreme Court has not said that mentally ill people cannot be executed. When the court prohibited the death penalty for intellectually disabled and for juveniles, it found that they were members of an identifiable group who had diminished responsibility for their actions and could not be considered the worst and most culpable or most responsible defendants. Lots of mental health experts think that people with severe mental illness like schizophrenia or bipolar disorder may have the same cognitive impairments that interfere with their decision making as other people in the group. And the American Psychiatric Association and the American Bar Association have called for a death penalty ban on those in that group who have that same or similar cognitive impairment. But so far that hasn't been recognized as an identifiable group. Some defendants also are so mentally ill as they lack all understanding of their crime and its consequences and may be considered mentally incompetent. And these people may be unfit to stand trial or be found not guilty by reason of insanity. And so they would not be found guilty at all or not be able to stand trial at all, so they would never even get to the death penalty phase. If they are convicted and become incompetent while they're on death row, so you were competent while you were convicted of a capital crime, but then while you're on death row you become incompetent, a person can't be executed because of earlier Supreme Court precedent. However, most people with mental illness, including those with severe mental illness, are not mentally incompetent. Mentally incompetent just means that they lack all understanding of their crime. 1 in 10 prisoners executed in the United States are volunteers or defendants or prisoners who have waived their right to appeal or waived their right to key trial protections. And mental illness also affects defendants' decisions to represent themselves, their ability to work with counsel, the jury's perceptions of their motives, and whether they pose a future danger to society if they're sentenced to life in prison. And so that can be reasons why mentally ill people are given the death penalty by the jury. So mental illness, you can't execute somebody who is young or who is mentally disabled, but somebody who has even serious mental illness can still be executed. And so that is 59 minutes of very unpleasant execution talk, but since we live in Texas, this is something that is very significant and pertinent to our state.